history of forensic psychology is kind of interesting. So historically, psychologists have had kind of a weird relationships with the court. Okay, originally, 100 years ago or so, mostly social workers would be involved with the courts, and particularly with juveniles. But as time went on, psychologists became more and more involved, and probably not until the 1960s and 1970s did we really see a lot of psychologists becoming involved in forensic work. There's been, and you probably from your own research or consuming of media, there's been some sort of egregious kind of work that psychologists have done in legal situations, right? That stereotype of the person getting off scot-free with, murdering someone. But the history of forensic psychology goes all the way back to a dude named Hugo Munsterberg. Don't you love that name? If I have another kid, I want to name the kid Hugo. This is his book, On the Witness Stand, 1908. And some of the things, 1908, and if you took PY 201, I know that you've been talking about the history of psychology, and 1908 was right at the beginning of psychology as a science. So Hugo wrote chapters on the memory of a witness, the detection of crime, hypnosis in crime, the prevention of crime, untrue confessions. These are actually contemporary issues that we deal with in forensic psychology all the time. There's a thing about false confessions. Maybe you've seen that in media stories. I've had to do evaluations for people that have, that there's been some argument that they made a false confession. Hugo talked about it in 1908. He's known as the father of forensic psychology.
At its basis, psychology is based on the theory of the mind. The idea that there is something inside us that makes us behave a certain way. The philosopher Descartes in the 1600s first began talking about the mind, a thing that's inside of a person that drives behavior. If you haven't read Descartes and his theory of the mind, it's a fascinating read. Even though it's from the 1600s, it really lays the basis of what all of psychology is eventually formed to become a science. Now, the first application of forensic psychology occurred way before psychology was established as a science. If you study the history of psychology, kind of turn of the century, 1880s, 90s, early 1900s is when psychology really began to become a science. The first application of forensic psychology that is sort of similar to how we apply it today occurred in 1843. In 1843, an Englishman named Daniel Mcnaughton shot and killed the private secretary of the Prime Minister. Mcnaughton was plagued by paranoid delusions that the Prime Minister, Robert Peel, was part of a conspiracy and out to get him. Mcnaughton hid outside of Peel's residence, and when Peel's secretary came out, Mcnaughton mistakenly thought it was the Prime Minister and shot and killed the secretary. Now, during his trial, 9 medical experts testified about Mcnaughton's mental state and agreed that he was all, quote, insane, end quote. As a result, he was found not guilty by reason of insanity. He was placed in an asylum, and that's where he remained for the rest of his life. The public became outraged about this and had a hard time understanding the concept of insanity, or that a person's mental state could be diminished to the point where they could not be held responsible for their crime the way you would generally hold someone responsible in a criminal manner. Also, Queen Victoria was pissed. Apparently, there were lots of people that were trying to assassinate Queen Victoria, and she was concerned that they would all use this basically insanity defense. As a result, the House of Lords demanded the Queen demanded that the House of Lords come up with a tougher test for this idea of insanity. They came up with the Mcnaughton Rule. The Mcnaughton Rule is a slide that's in your packet. Now, the Mcnaughton Rule reads, "The jury ought to be told in all cases that every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his crimes. Until the contrary be proved to their satisfaction, and to establish a defense on the grounds of insanity, it must be clearly proved that, at the time of committing the act, the accused was laboring under such a defect of reason, from desurse of mind, as not to know the nature and quality of the act he was doing, or, if he did know it, that he did not know what he was doing. Fascinating rule from 1843. Later in the webinar, we are going to talk about insanity pleas. We're going to talk about the particular and specific laws pertaining to insanity. And you'll find out that many of these laws follow the Mcnaughton Rule.